Today's presenter, Russell Jackman, is a graduate of the McGeorge School of Law, University of Pacific, and was admitted to the State Bar of California in June of 1994. He has been vice chair of the California State Bar's Law Practice Management and Technology Committee and a member since 1996. He works specifically with law offices and attorneys that need to get the most out of their legal technology and creates PowerPoint presentations for opening statements, direct examinations, and closing statements to be used in court, and can work with attorneys directly to filter their documents and images so that they have the most powerful visual presentations possible. He also works with law offices and solo attorneys to upgrade their older systems to new ones, troubleshooting existing setups, and training attorneys and staff on Microsoft programs. He is available for remote access consulting on technology-related issues, so please feel free to contact him at any time.
Hello, my name is Russell Jackman, and today for the Center for Continuing Education, I am speaking about the UPL, or better known as the Unauthorized Practice of Law. We were referring to it quite a bit during this lecture as UPL. So the very first thing we need to do is to sort of zoom out and take a broad view of the entire UPL term and define to ourselves what is UPL. And I guess the best way to start, obviously, is Black's Law Dictionary, which is that the unauthorized practice of law is the practice of law by a person, typically a non-lawyer, who has not been licensed or admitted to practice law in a given jurisdiction. That seems pretty simple on the face of it, but keep in mind it can also include attorneys. Okay? So a recent law school graduate, here's an example of how UPL could be applied. A lot of people don't realize there's a lot of different scenarios that could happen. Like, for instance, the example would be a recent law school graduate who's studying the bar exam, enters into a deal with a friend who's starting a company. She'll help draft legal documents for his company in exchange for a free room in his apartment. So, in other words, she's not exactly an attorney yet, but she is studying the bar exam and she did graduate law school. So is this an instance of practicing law? Or is this an instance? A paralegal who works for a busy litigation attorney drafts and files a litigation pleading form for him, but without him reviewing it first on a day when he's traveling and unavailable. Is that, I mean, especially if it's something that had to get out to court immediately and the client would have a situation that would cause harm to his or her case, is that something that is UPL? I mean, that's another good question. And then finally, like a trust and estates attorney who's been suspended from the California State Bar membership, who continues to do work for clients in order to finish wills and estate plans that she began for them earlier. Yes, in a situation like this, you could say, well, they should just find another attorney. And a lot of times they do, but in situations where it's people who are poor or indigent or have a trouble communicating with anyone other than the attorney personally, or that they have a personal relationship with that attorney that they don't necessarily trust giving that information out to another person, that can be, another example of where UPL isn't as black and white, isn't as something as cut and dried as just saying, well, it's just a person who's practicing law without a license. There's a lot of gray area, and that's one of the things that we'll really be talking about today during this lecture, is the challenges of dealing with the fact that you just don't necessarily you have a lot of situations, and there is the dichotomy of whether or not you're punishing people for having access to the law versus regulating the legal industry for compliance and for reliability. So why do you have UPL? It's the obvious one, at least right on the face of it, is for public protection. People who are holding themselves out as attorneys that don't quite meet the requirements could cause serious legal harm to people, doing jail time or losing millions of dollars based on the incompetence of someone that just doesn't know the legal system. And that's why we have bar exams. That's why we have, bar associations and so forth, is to regulate those things and make sure that people don't violate the laws of their particular states. And so UPL is critical towards maintaining the efficacy of the profession. The reputation of attorneys is truly at stake with UPL. That's the fact is, when you don't have any business that has got some level of profession, a true profession, where you have to have regulation, where such like medical doctors or dentists or psychiatrists or what have you, if you don't have a viable board that can make sure that those that are practicing are licensed, then anarchy breaks out and the value of the profession goes down. People don't trust it. People say, well, you're just a bunch of quacks and or a bunch of shysters or a bunch of fill in the blank as far as your low level reputation goes. And so people want to know who they're dealing with, especially when it comes to legal matters, has a level of trust they can put into it, because they're putting a lot at stake in the hands of an attorney. And then the administration of justice and the court system. UPL is really important, because if lawyers go and screw up cases or if non-lawyers go in and clog the justice system up with incompetence, judges will be, and the court system will grind to a standstill, because they'll be working so hard in trying to manage the raw incompetence of people who aren't licensed and don't really know the system, but say they did, because they watched Perry Mason in a bar last night. That's not going to quite cut it. People do often think they have a much greater understanding of how the court system works, and when that becomes part of every case, people unfamiliar with how a court system works, the whole system would fall apart. But is it separating the public from its own ability to control itself legally? That is the big question. Not everyone can afford attorneys. Not everyone can afford, to have legal counsel of the highest order. Even when you talk about legal clinics and public defenders, and the fact that pro se appearances are built into what is part of the court system itself does lead people that gray area where, if you're representing yourself, you can do that. If you represent somebody else and you do that you're not allowed. Yet sometimes people turn to these other folks, the quote unquote jailhouse lawyers, in that sense, because they have nowhere else to turn. And are those people to be denied representation in our legal system because they can't find a lawyer, or they've had a bad track record with a lawyer, or they can't afford one, or so forth? In some instances, attorneys who are properly licensed and in good standing in the state are allowed to practice, for instance, in a place like California. So attorneys that practice only federal law as immigration may practice in California, be licensed in another state. And in those instances, you look up, make sure that they're licensed by looking up their state bar number and looking them up in the directory for their state. So there is always this, there's also another level of UPL, that comes in, which is how states use UPL to keep lawyers from necessarily practicing in their state for the lack of reciprocity. So in other words, they say, you don't know the laws well enough in California to do real estate law here. You need to become an attorney licensed in California to do, trusts or whatever laws that are particular to California, but not federal laws, which are universal for all states. So the things that are strictly a matter of California-based law, you still have to know and be licensed from California to do that, or prove that you do know that law in that area, but not the same for federal law. There is a very big wills and crisis and trust crisis that is going on in America right now. And wills and trusts are popular items to bypass attorney fees and costs. We see a number of do-it-yourself companies, but mostly the one that was the kind of the premier of do-it-yourself legal forms is a company called Legalzoom, and they have low-cost wills that are only $69 to get prepared, and they have provided, at this point, probably more than 1 million wills across America and around the world, actually. And so do-it-yourself estate planning has become something that people have talked about and in lots of different venues and lots of different places, because I guess the big question is, yes, a will and a trust made by Legalzoom is not airtight or could handle a multi-million-dollar estate, but for someone that has very few assets and no children and nobody really to take responsibility for, if they're single or whatever, a $69 will with holes in it is better than no will at all. So as long as it's valid, and that's obviously always a big question. Sometimes they'll prepare a will on Legalzoom, but then it'll never be signed, or they won't have the right number of witnesses, or the types of witnesses will be wrong, something along those lines. So questions have arisen whether do-it-yourself legal providers are engaged in UPL. Legalzoom has been sued in a number of different states for UPL. And some attorneys, though, have noted that that they feel that when people use a do-it-yourself system, that they lull clients into a false sense of security, and that they actually never get it reviewed by anyone. And of course, the only way you really know how well your will really works is when you die, because after that, it's a little bit too late. So, there's certainly been some discussion about that. And 6 out of 10 people do not have wills. And it's the surveys that show from caring.com, only 4 in 10 Americans have a will or live in trust, even though that older adults do. But a lot of them, there's still a lot that, especially there's about 20% that are 72 or older, and about 40% of baby boomers don't have estate planning documents, and that's a lot when you really sum everything up. So what can be done to help bridge that gap? There's been, obviously there are a number of document prep services and legal document self-help centers, or ones that have paralegals or legal assistants that will help draft documents. But is the big question. Is that unauthorized practice of law? And on the one hand, you'd say no, because they're helping people get this information. On the other hand, are they giving out advice that only an attorney should be giving? You know, it's one thing to help somebody fill out a form by saying you need to put your name here, you need to put your name there, versus there's a dollar amount here. What dollar amount should I put there? You can't give that advice. You can't say you should put this here, you should put this there if you want to do this. In other words, the walking through and actually giving advice on not just the what to put in what location, but the content of what to put in there and how you should word it. That's a bigger question, and it's hard to regulate those things and to know where one part of advice ends up versus another. That's where we have the trickiness going on with aggressive UPL pursuits. If they shut down these clinics, these legal document assembly places, then people may just not get them done at all. And if that's the case, does that hurt the administration of justice more than a false sense of security? So there's been a complaint alleged that Legalzoom is engaged in the unauthorized practice of law, false advertising, unfair competition, and other claims with respect to preparation and filing of trademark applications for the U.S. Trademark Office. And this suit is about creating an equal playing field for his firm to compete with Legalzoom. I can't do what they're doing, but they can do what I'm doing, he says. So he points to like things like malpractice insurance, having to do CLEs, other overhead costs that an attorney like himself has to absorb, and Legalzoom does not. And he pointed out that if he operated like Legalzoom, he would be disbarred. So it's, again, now you don't necessarily need to be a lawyer to file a trademark application. You can file your own personal trademark. But the question is, when the Legalzoom people are helping people fill those out, are they in the word giving actual legal advice to the people who are working on it? And is that a greater evil than letting people who normally wouldn't be able to file trademarks because of the cost of getting an attorney? Does that outweigh the harm versus the good that people who don't have money, a lot of money, can get their trademarks or attempt to get their trademarks? Now, Legalzoom said that they meet all applicable ethics regulations, and we are seeing an aspiring competitor angrily lash out after failing to compete in the marketplace. We'll not be distracted, but maintain our focus on the critical mission of increasing affordable access to the law. So again, how much of this is regulating the profession? How much of this is predatory nature by certain attorneys to not have competition from lower cost services? In other words, attorneys are saying that because these will mills are out there, and that they're why you have these different legal document processing companies, those are eating into the actual profit margin of attorneys that get to do these sort of document things for relatively easy work and charge quite a bit of money for it, which again reduces the accessibility of legal, the legal system to different people. Now, of course, lawyers are, not necessarily in the business for charity. They want to make money too. And so you're sort of running into an instance, and it's more than one. And LegalZoom is a really good example of it, where the UPL, these other companies feel that UPL is being used as a way to drive off competition and to continue to charge too much for jobs that are relatively simple and relatively mechanical, that were always relegated to attorneys in the past because there wasn't an easily automated way to do it. In years past, you relied on things like the attorney's law office to be able, because people didn't even own typewriters. Owning a typewriter was a big deal, and most people didn't know how to set up a pleading document. Most people didn't know how to find forms. You had to go to a law library and work your way around, and then you had to Xerox stuff, and you had to type it with carbon paper, and you had to file it in the right department, and all these other things that intimidated a lot of average common people that didn't want to do it, and so they were willing to pay a lawyer to do all those things. But now you can automate almost all of these processes that you really don't need an attorney for. I mean, they can all be done electronically and quickly and without that much of a specialized knowledge behind it. Now, this isn't saying that, LegalZoom is going to go into court with you if you wind up screwing something up and you wind up getting sued for it. That's another thing too, is that, LegalZoom has a way of waving their arms and saying, read our disclaimer. We told you this would happen, and not necessarily, being there for you if something goes wrong. Now, the Arkansas Supreme Court saved LegalZoom from a class action lawsuit in 2013, and even in Missouri, they weren't able to get by with their class action saying LegalZoom was UPL, and legislation in 2016 was passed by North Carolina that said that the practice of law does not include software that generates a legal document based on a user's response to a legal question. So they pretty much opened it up. And if you notice, the Black's Law Dictionary, the definition, if we go back to that from the beginning, said that a person who practices law. And so it sort of doesn't include computers technically, the actual definition. It has to do with a person practicing law, not a machine. And when the day we get robo lawyers coming into court, who knows? But that's going to be a very interesting situation when/if it ever happens. UPL may include work performed by immigration consultants that are giving you forms for you to translate, but can't provide people with legal advice or what form to use. Okay, if they do, that is UPL. Immigration consultants cannot represent you in court or provide legal advice. If they do, that's UPL. And if an attorney practices law while their license is suspended or after they're disbarred, it's also considered UPL. So there's lots of different ways that UPL kind of twists and turns. It's not as simple as just saying, well, this is just to punish bad attorneys or people who are too lazy to take the bar exam. So California has a complaint form that kind of follows these particular questions. For instance, did you hire this non-attorney? Did the non-attorney provide legal services? For example, appear in court, give legal advice, or prepare legal documents? Did the non-attorney say he or she was an attorney? Does this complaint involve allegations of a non-attorney unauthorized practice of law where a person 65 years of age or older is victimized? And does the complaint involve allegations of a non-attorney unauthorized practice of law where a person who is incapacitated, infirm, disabled, incarcerated, an immigrant, or minor was victimized? So you can see that they have actual really areas where they would consider, I think, hot button items, which is someone who is 65 years of age or older, someone who is incapacitated, infirm, incarcerated, an immigrant, or minor. If they see that this sort of thing is going on and the improprieties are aimed at these particular folks who don't have as much knowledge over what's going on, and they aren't in a position to be able to bargain or to shop around for other attorneys or to even understand that there are alternatives. Those are used as special classes to make sure that they're protected from UPL in California. But I think it's pretty typical in all the states. So a little bit of Virginia law, which is that pursuant to Virginia UPL rules, they say that if anyone undertakes for compensation, direct or indirect, give advice or to counsel an entity or person in any matter involving the application of legal principles, or anyone that drafts legal documents that affect the legal rights of somebody, or that represent another entity or person, or negotiates the legal rights responsibilities on behalf of another entity or person. And then they do give exceptions that say, for instance, a non-lawyer may work with a paralegal or other administrative support under direct supervision of a licensed attorney, or that a non-lawyer may prepare forms of wills or trusts of general application, may submit proposed language to an attorney for review, the lawyer's acceptance, modification, or rejection. So that one gets a little tricky because it says that you can create the language, but you have to have it checked by an attorney. So it's, again, the process of giving advice is somewhat allowed in wills and trusts as long as it's okayed eventually by an attorney. So just the act of preparing a will or trust in Virginia, even if you're a non-lawyer, is not UPL in itself. It is only that before it's submitted as a official document, it has to go through an attorney first. So in other words, again, you can see how that gray area is the UPL. It's not the simple act of just preparing a will when you're a non-attorney. And a non-lawyer may also furnish a client with routine forms or contracts of generally accepted applications, such as beneficiary designation forms. Again, things that just talk about very, very objective descriptions, you know, name and location and address, things that don't require actual like qualitative opinions or discussions over whether this thing should be submitted. Here, for instance, they also have qualified advanced directive facilitators in Virginia that that can be certified through a program that will allow technical advice, consultation, and assistance in completing and executing advanced medical directives to people who are in the hospital and involved in accidents that don't have any, or you know, a heart attack or something like that. They don't have a will, and they don't have an advanced medical directive. The qualified advanced directive facilitators are not considered lawyers or giving legal advice when they walk people through the medical directives so that they can get the medical advice and help they need because they hadn't filled it out before. So this was an exemption that was made for Virginia based for hospitals and hospice care providers. So again, UPL isn't always a solid thing, and that they're a lot of times finding exceptions for it to help individuals get access to the law that they really need. So let's talk about some major cases. And one of the biggest cases there is the Florida Bar versus Moses. Okay. This this case created a lot of different exceptions to the different things that were going on. For instance, saying that in-house counsel, eviction representation, pro se appearances, and federal tax practice would all be accepted from being treated under the UPL laws in Florida. But it also said that UPL, you need to be an attorney for that UPL is also not to be applied to anything in federal practice, bankruptcy, for out-of-state attorneys, immigration representation. It does allow for self-help legal forms for non-attorneys to help with self-help forms. But it says that, you know, you definitely need to be licensed for different things. You have to be an attorney for some of the things that really require intense representation in court, like, for instance, immigration and the federal practice and bankruptcy. You can't just do that and be a non-attorney. There is a very important level of the state's interest versus restrictions, which is that the justices in Ohio ruled that that an attorney was not practicing in Ohio or providing legal services in Ohio would not be violating the Constitution, and that the 14th Amendment was considered to outrank the Ohio rule on unauthorized practice, because they said that the 14th Amendment needed to be there to protect an individual's right to pursue and continue in a chosen occupation free from unreasonable government interference. And the Ohio rule violated that limitation on state regulation because it does not bear a rational relationship to any discernible state interest. In Ray Jones, which is, again, a really important case that has been echoed in other and referred to in a number of other cases. Because if the state does not have a rational interest behind why it is claiming it's protecting someone or something under the unauthorized practice of law statute, then it will not be found to be constitutional. So the state has to, when it is drafting its UPL, the bars for creating their UPL laws, they have to not just say, you know, no one anywhere can ever do anything legally, because there is a limit to what is reserved only for attorneys. And they want to tailor that as closely as possible to give the average person a chance to do the kind of legal work that they may be capable of doing themselves without the need of an attorney. So, for instance, here's several other cases. Peters Production, recognizing that corporations are a legal entity separate from its officers, shareholders, or other constituents. And Michigan law does not allow a non-lawyer officer or shareholder of a corporation to appear in court proceedings on behalf of the corporation. Okay, and after disbarment, an attorney had no standing to continue to represent a bankrupt corporation. And then finally, where a corporation and an individual is not licensed as an attorney, and operating collections agencies took assignments of claim from their customers and brought suits on the assigned claim, which the customers retained an interest, the corporation and individual were engaging in the unauthorized practice of law. So you can't have a corporation and an individual who's not an attorney go around and file lawsuits and have them say, well, it's representing itself in pro per. That's just, you can't bend the law that way and the legal practice that way. South Carolina Supreme Court explained that the preparation of legal documents is when the preparation giving advice, consultation, explanation, or recommendations on matters of law. Further, instructing the other individuals in the manner in which to prepare and execute such documents is also the practice. And then in 2007, we have that the UPL was found when a non-lawyer assisted a neighbor filling out the blanks. They found that he exceeded the role of a mere scrivener, which the court defined as someone who does nothing more than record verbatim what another instructs him to record. And of course, you know, a very big question to this is, what does this mean for librarians and for law librarians who, you know, give people who want to research the law, and if a law librarian says, okay, the case that you're looking for is over here, you need to look in this sort of case area over there, is that the unauthorized practice of law? You know, good questions to ponder. In Virginia, Home versus Wilson, there was a unauthorized practice of law against a hospital and two doctors. The representative, the hospital should have gotten an attorney and did not, and the administrator of the hospital wanted to go forwards, saying that he was truly the representative of the hospital, and that he was initiating an action in pro se, in other words, representing itself by stepping into the shoes of the hospital as an administrator. But they said that that existed only to permit somebody to prosecute a cause of action belonging to the decedent's beneficiaries. It does not maintain to any cause of action personal to himself. So that an administrator's right to action only exists when you're talking about the administrator himself being brought up on any charges. But he can't represent the hospital because he's not an attorney and he wasn't hired by the hospital to be its attorney, and was not brought in that way. So you can't defend yourself and defend an entity at the same time, and use the fact that you're defending yourself, being your own attorney, as a way to defend a company or corporation, or in this case, a hospital. So this brings us to the very tricky issue of in-house counsel. And we see in the model rules 5.5D through E, the safe harbor for in-house lawyers by the ABA. And it said that in 2002, it meant to create a safe harbor for in-house lawyers. And it's relatively easy to comply with model rule 5.5 when it says that it does not create an unreasonable risk to the client and others because the employer is well situated to assess the lawyer's qualifications and the quality of the lawyer's work, which is true, but we've seen a number of different problems that occur from the way that these in-house lawyers then act once they are as in-house lawyers. And as an example, we'll see how that kind of goes on here. Now, the ABA adopted the rule for the regulation, but states that this topic can vary on a number of subjects, including whether the registration or limited admission of in-house lawyers, are court appearances on behalf going on, are pro bono work for clients other than the organization employer authorized, is time worked under this rule to be waived in for general bar admission purposes, are the in-house lawyer satisfying his legal education requirements, are annual payments or going to be paid for bar membership, and that has become a sticky mess actually for a number of different local bar associations, and we'll go on. We'll describe that shortly. For instance, Gucci versus Guess Incorporated. Moss worked for Gucci in New York, and he'd been admitted to, he was a member of the State Bar of California, but he was inactive in his California bar status. So he wasn't authorized to practice law in California, but he was working with a company that was in New York. And he wasn't a member of a bar in any other state. So Gucci thought, because he had held himself out as a lawyer in California, and that he was initially in good standing and then went inactive, but they didn't know that he went inactive, that they relied on his bar membership, his standing as a bar member with California, to treat him as an attorney and have him file different lawsuits. And the court held that there can be no real dispute that Gucci has proven that had a reasonable belief that Moss was an attorney. It identified multiple factors, such as when it hired Moss, it knew he had a law degree. Gucci hired Moss to do legal work. Throughout the employment, Moss provided legal services to Gucci, including appearing before courts and administrative agencies, filing trademark applications, handling employment matters, and negotiating leases. Gucci paid Moss's California bar membership throughout the employment. 6 current and former executives submitted declarations stating they considered Moss to be an attorney, and the court said that this is a more than sufficient evidence to support the conclusion that Gucci had a reasonable belief that Moss was its attorney throughout the relevant period. Any other conclusion would be clearly erroneous. So this was a situation where they actually said that you could have reasonable belief that somebody who was engaged in the unauthorized practice of law but hid it from the client would not be punished for trusting someone that committed a UPL offense. And in a much bigger case that actually happened relatively recently here, close to where I live here in Northern California, a very interesting situation happened with Oakland City Council candidate Chris Young being suspended by the State Bar of California. He was the outgoing council member, but he hasn't been eligible to practice law since last September. He was not authorized to practice law in California under state bar records. Under state law, it's a misdemeanor for anyone to practice law or even hold themselves out as entitled to practice law without being an active member of the state bar. And according to his bar records, Young was suspended on September 1st for failing to comply with mandatory continuing legal education requirements and not paying state bar fees. Current status is inactive. He's been suspended by the bar on 2 previous occasions, once in 2010 for failing to pay bar fees, and again in 2016 for failing to pay bar fees. He said that as general counsel for GoFundMe, he actually doesn't provide any of the legal services general counsel usually provides. He says he represents GoFundMe. He doesn't represent GoFundMe in any courts, any adjunctive venues. He doesn't even review or approve any internal legal documents, including contracts with employees or other companies. You don't practice law as general counsel, said Young. You practice law when you're admitted to practice in court. Young added that some of his colleagues at other tech companies who serve as general counsel also have an inactive status with the state bar, and this is legal because they work as executives, not as attorneys. That's the reality of my job. I have a legal department. I have attorneys who render advice to executives. I'm one of 6 executives of the company. So where does that leave us at? And that's a very good question, a really difficult question to ponder, is whether you can have someone who says they're an in-house counsel, yet they're not acting as an attorney and shouldn't be relegated under MCLE requirements or paying for their bar fees because they're inactive. What they're actually doing is working as an executive. You have that kind of juxtaposed with what we just saw in the Guest case, where Guest was believing that someone was an attorney, and the guy held himself out as an attorney, even though he wasn't an attorney. So where do we go from there? Is a guy like this actually a general counsel, and truly he doesn't practice law because you have to be admitted to practice in court, and that's what really defines what law is about? Is he really like not even reviewing or approving any internal legal documents or contracts or employees with other companies? On an aside, my own personal story is that I was general counsel for 2.5 years for a major car dealership in Northern California, a set of car dealerships in Northern California. And during those 2.5 years, I never once thought about not paying my bar fees. That was, or keeping up my MCLEs, because I thought what I was doing as in-house counsel was absolutely legal work and acting as an attorney. And I did a lot of contract reviews and policy reviews and talked, to employees and dealt with employer situations. In fact, to be really honest with you, if this guy is saying he works as an executive and not an in-house counsel, I really don't know what he does, because it doesn't make sense how he could function in his job and not run into, even if you just say you're an executive, executives have to approve internal legal documents. They have to approve contracts. They have to deal with employees. And people deal with people differently when they know they're speaking to an attorney. There is a different level, not just of respect, but people thinking, I don't want to say something can be used against me. I have to be more careful around my P's and Q's because as an attorney I'm dealing with here, or maybe they're more respectful and they say, you know what, I better be straight with this guy because I know he's an attorney and he means business and that sort of thing. It's I don't know how a person like this guy can separate himself from the requirements that are set for being an attorney and get the benefits of being an in-house counsel and not deal with things such as MCLEs and paying his bar fees. I don't think that it's fair for him to go and file for inactive status and be able to feel that he's immune from the requirements that he is truly taking advantage of to be in this position as an in-house counsel. But I don't believe there's been a ruling in this case, so we'll be. Just the fact that he's been suspended by the state bar, though, says that unless he takes it to the Supreme Court or California Supreme Court, there's a pretty good chance he's not going to get his way. And in the end, usually when it comes to something like this, unless there's an absolute knockdown, slam dunk constitutional violation, they're going to go with the courts are going to rule with the state bar association on something like this, as opposed to letting someone who has sort of a flimsy logical reason for doing what he's doing necessarily get away with it. So I'd be surprised if this changed, or he didn't have his his bar membership reinstated without paying for his outstanding legal membership fees and his and getting his MCLEs up to. And by the way, I know a great place where he can get MCLE credits from if he is looking for extras. So, if he's having trouble getting MCLEs, he should give me a call. Anyway, sum things up here. Well, let's talk about punishment for violations, because that's also important to know too. So in California, Business and Professions Code, you can be punished up to 364 days in jail, fined up to $1,000 or both jail and a fine. So that's pretty serious. In Virginia, the penalty for practicing without authority is that a person who is practicing law without being authorized or licensed shall be guilty of a class 1 misdemeanor. And in Florida, they say that the penalties for any person not licensed or otherwise authorized to practice law in that state, or who willfully takes the name, title, or description implying that they're qualified, is recognized as qualified to practice law in the state, commits a felony of the 3rd degree. So you have varying levels of punishment for different violations, none of which are very positive. And they're all pretty severe, because they really, each profession wants to be able to, each bar association wants to be able to say that it respects the profession to a great degree. And if they know that people are acting out of line, especially people who didn't bother to get licensed in the first place. It's a little bit different when you're an attorney and you violated UPL by practicing when you were suspended. But if you are never an attorney at all, and you're doing it, you could be in for some serious problems. So some conclusions that we can come to here is that the unauthorized practice of law has some positives. The enforcement of it has some positive elements to it, and that is that it does regulate the practice, make the law run more smoothly, that it protects the public from scam attorneys, and it is there to be as a disincentive for people to even try to do the unauthorized practice of law. It exists as a deterrent as much as an actual mode of punishment itself. It's not like the state bar itself makes a lot of money off of pursuing the unauthorized practice of law, but by protecting the public from scam attorneys, it's getting the job done. It provides a level of punishment for bad attorneys. So, it gives a framework once they find that there is UPL that has occurred, that these attorneys can then be punished for it, or people who are not attorneys can be punished for it, and also gives a level of retribution for the victims. So they can say that because of the UPL that occurred, that maybe they would be able to get a new trial, like in the case of Moss, sanctions that were by the Guess versus Moss case, because the attorney wasn't licensed, but the Guess company had relied in good faith on his advice. They were able to not be found to have, they were able to find themselves another attorney that could give them the right advice, and the wrong advice that was given to them by this unlicensed attorney was remitted. They were able to get another shot at it. Or sometimes you get a mistrial, or you may be able to get the trial redirected based on having a new attorney subbed out and having the UPL attorney removed. And one of the UPL's positives, and I'm not sure how positive it is, but it's part of why the UPL does what it does, is it makes sure that the bar associations get paid, because by enforcing UPL laws, they make sure that people like this last individual pay their bar fees on time, and that they get their MCLEs done, so that if they don't do those sort of things, there's a level of punishment, and there'll be the licenses will be removed, and then they'll be in UPL until they comply with the requirements. But there are obviously UPL's negatives, and we've discussed them earlier, which is that it can be applied unfairly. For instance, UPL tends to be against individuals. It's not against larger firms. It's more or less, it seems to be brought up a lot of times on people who are trying to help folks who are low income and that have a gap in the ability to get legal services, usually because of economics, but sometimes because of other disadvantages. It could separate low and average income people from the law, so creating more of that legal gap, which creates to a very stilted sense of justice, the idea that only rich people can afford the right attorneys, that went to big law schools to defend themselves in a situation like this, and that if you're lower income, the law is not supposed to be meant just for attorneys, period. Most of the law is meant for the whole public, and that people should have a right to represent themselves ultimately if that's what they feel is the best mode for defense, and that aggressive UPL pursuits discourage people from being able to defend themselves if they thought that they could, or they thought that they would be held under the scrutiny of UPL. And if that led people to not pursue their legal rights or to defend themselves based on their legal rights, that would be an injustice. And as we've seen, UPL is extremely difficult when applied to in-house counsel situation. It's because in-house counsel is a hybrid, you're in a company and you're not necessarily in court. Are you really acting as an attorney or not? If so, where do you cross that line? If not, where do you cross that? And so there is a lot of questions as to what if in-house counsel safe harbors are giving attorneys too much leeway, or is it giving them not enough? So in other words, if attorneys feel that they're too exposed, will that drive them out of the in-house counsel position, making them go back to law firms, costing companies more that like to have counsel in-house, save them money rather than contacting a law firm every single time and going through that cost? But on the other hand, it can't be used as a shield to keep attorneys who are really giving legal advice and should be taking MCLEs, not paying bar fees, and still doing the functions that most attorneys are using. And how do you even keep track of an in-house counsel 24 hours a day and see whether or not he's talking to an employee over something that might be a legal subject? He might be giving this bit of advice, which happens to deal with a contract, would be a legal subject. That you have all sorts of scenarios that can come up on a daily basis, and how do you keep track of that? And is one piece of advice UPL? Is 100 pieces of advice UPL? Technically they would say that even the slightest bit of advice once is a matter of UPL, but we know realistically that's just not the way anything like this could be managed. And then finally, the fact that America's our underworld, under medically directive, and aggressive UPL can make that worse. And that's why we've seen other states make exceptions for people to give qualified medical advice. On the other hand, you don't want just anybody giving, legal advice or having people sign wills or trusts that don't know what they're doing, because of course that can have, implications that can never be fixed once the person is dead. And so that is always going to be something that's going to be challenged. And as we run into a situation where technology becomes greater involved in things like creating automated systems for handling a lot of legal documents, and so you just like a lot of like sort of like TurboTax, and there is a a Quicken will maker, and there are Zoom and Legalzoom, and you have LifeLock and Legal Shield and other companies that are getting into the legal document automation process. At what point in time are we going to accept the fact that a lot of these things can be done without actual advice being given, and that is an unauthorized practice of law either? Sometime a lot of this stuff will all be automated and the human element will be removed. And we'll get to see a lot more clearly where human lawyers make a difference and where machines kind of make up the rest. So if anyone has any questions about this, I'd be happy to talk to them. Here's my contact information, and I hope that you enjoyed today's talk. Thank you very much.